Good morning, everybody. My name is Colin Archibald. I'm a partner in the Commercial Disputes and Regulation team at Shepherd and Wedderburn, and I head up the firm's Property Dispute Resolution Group. And a warm welcome to this morning's virtual Property Dispute Resolution Group seminar on commercial leases, current issues and recent developments. And I'm joined this morning by my colleagues Lawrence Morley and Daniel Bain. For those of you that joined our last session back in June, when we looked at the topic of managing property portfolios, we looked at a more general round of topics with a Scottish focus in relation to ensuring enforcement of landlords' rights and tenant obligations under leases in anticipation of a tightening of the economic environment. And I think that sense has been borne out by everything that has happened over the last 5 months or so. We'll obviously have to wait and see what Jeremy Hunt has to announce a little bit later on this morning, but we're certainly heading into a recession, it would appear, and some of the economic factors that influenced the topic we chose in June are just as relevant now. And so what this morning is designed to do is to build on some of the ground that we covered earlier in the year, but also to look at it from a Scottish and an English perspective. We'll look at some current commercial trends, some issues around the status of tenant occupation, and also some issues that have come across our desk in recent times and come through the courts in relation to break notices. So hopefully these topics will all be of interest to you. If you have questions as you go along, you'll be able to submit them through the Q&A function, and please just submit them as you go. And we should have, hopefully, a little bit of time for questions at the end. The one other piece of housekeeping that I ought to mention is that we will be sending out a recording of this morning's session and the slides for it at the end, so they will follow in due course. That aside, I think it's just a question of handing over to our speakers. Lawrence is going to talk about the position in England first of all, and then is going to hand over to Dan. So a warm welcome to Lawrence, and take it away.
Thank you, Colin. I'll just share my slides. Colin, can you see those just before I get going?
I can, Lawrence. Yes, thanks.
Okay, good job. Thank you very much. Right, good morning, everybody. As Colin said, my name's Lawrence Morley. I'm a solicitor specialising in property litigation, working out of the London office. So I'm dealing with property litigation work in England for Shepherd and Wedderburn. I'm going to touch on a couple of particular topics that
the perils of virtual seminars. If there's an internet problem, we'll hopefully get that sorted in the not too distant future. Apologies for that.
Oh no, while we're waiting for Lawrence to rejoin, I can maybe just start my talk, which was intended to follow on from Lawrence's, but as Colin says, it's the perils of doing these things virtually. You can't legislate for for unexpected technical issues. So if I just get my slides up on the screen. I say this was really intended to follow on from Lawrence's and really look at the two topics that he had sort of picked out from a Scottish perspective. That whole sort of lease versus license debate, which he was just about to get into, and also looking at break notices from a Scottish perspective, and in particular some recent Scottish case law. So I guess just starting with the lease versus license issue. I mean, the position north and south of the border is broadly the same, although in Scotland it perhaps assumes a bit less importance for reasons that Lawrence will talk about when he rejoins, in terms of the importance of the issue in England, and in particular legislation that applies in England. But it can be important in Scotland, as we'll come on to see. But in terms of determining whether a contract is a lease or a license, there are a number of factors that need to be considered, and the three main ones really are up on the slide there. The first is to look at the express terms of the agreement, and in particular, what have the parties intended? Have they called it a lease? Have they called it a license? But it's important to bear in mind that, as is the position in England, calling the agreement a lease or a license is not necessarily determinative in itself. It's important to look at all of the terms of the agreement and all of the various factors, and coming to a view on whether it's a lease or a license. So perhaps the sort of main factor to be considered is the question of whether there is exclusive possession, whether the tenant or licensee, the occupier of the property, has exclusive possession of the property. Generally speaking, if there is exclusive possession, then it's very likely to be a lease. But if there isn't exclusive possession, then it's very unlikely to be a lease. And it's also important to consider whether the agreement lacks any of the essential requirements of lease. And those essential requirements are, there needs to be parties, a landlord and tenant. The subjects, there need to be subjects of let, as in the property, that needs to be clearly defined. There needs to be a rent, and there needs to be a duration. To be a lease, all four of those elements need to be there, and if any of those elements are not there, then it may well be a license. But just a note of caution, again, it's not necessarily, you can't always be hard and fast about this. So, for example, sometimes if the parties have entered into a lease and it lacks a duration, in certain circumstances, the law will imply a duration of a year. So there aren't any hard and fast rules. You have to, as I say, look at the terms of the agreement as a whole, look at these factors, and ultimately come to a view. Now I'll hand back to Lawrence in a moment, who's just rejoined. But just to kind of explain, I mentioned earlier on it's perhaps not as important. The distinction is perhaps not as important in Scotland as it is in England, for reasons that Lawrence will explain, but it does still have some importance in Scotland. There's two main reasons for that. The first is that a lease gives the tenant a real right, which is valid against the landlord's successors. Now, what that means, a real right essentially is it's akin to ownership. Ownership of land is a real right in law. And a lease is a real right, provided all the essential requirements of a lease are there, and that and what that essentially means is that if the property changes hands, the new owner takes title subject to the lease. That isn't the case with a license, which is personalised between the parties to the license. Also, the Scots law principle of tacit relocation applies to leases, but not licenses. So what tacit relocation, as many of you know, does is that if notice of termination is not served at the end of a lease in Scotland, it will continue. If the lease has a duration of more than a year, it will continue from year to year until the notice is terminated. If it's got a duration of less than a year, it continues for that duration, so on until notice of termination is given. So that applies to leases, but it doesn't apply to licenses. So again, that's another reason why the distinction is important, and why sometimes parties, will want to enter into a license, will want to create a license to avoid that sort of effect at the end, to essentially create a sort of a fixed term, if you like. That was really all I was going to say about leases and licenses in Scotland. At this point, I think I'll hand back to Lawrence, who can talk about that in England. So, Lawrence, I don't know if you want to share your slides now. I should come back.
Yeah, thanks. Thank you, Dan. Can everybody see those? Am I going perfect? Lovely job. Yes, thank you. Sorry about that, everybody. The wonders of modern technology. So I'm going to be touching firstly on the matters from an English perspective that Dan has been kindly talking about to fill in my absence. It's really important in England, the distinction between a lease, license, or a tenancy at will, because of Part 2 of the Landlord and Tenant 1954 Act. That applies in England and Wales only, so it's not something that Dan will be touching on. And the 1954 Act is particularly important for tenants and for landlords, because it gives a tenant occupying premises for the purpose of a business a statutory right to renew its tenancy at the end of the term, and the landlord can only oppose that right on certain specified grounds. Now, a lot of leases contract out of the 1954 Act, where the parties agree before the lease is entered into that the 54 Act won't apply, so there isn't a right for a tenant at the end, but otherwise it will. And it applies to leases, and it doesn't apply to licenses and tenancies at will. And if the 54 Act doesn't apply, then the tenant or the occupier has no right to a renewal at the end of the term. So it is the distinction, and to understand the difference between those types of occupation is particularly important. So just to summarise, really, what is a lease in terms of English law, and this will be largely the same in Scotland, and Dan's touched on a couple of the points. It's the grant of a right to exclusive possession of land for a determinable period of time. And Dan touched on the key element, really, of exclusive possession, and I would echo that's the case in England. The leading case of Street and Mountford sort of defines what a lease, is going to be, being a document that grants exclusive possession for a fixed or periodic term at a rent. And if it has those things, then the document will point to a tenancy or a lease rather than a license. But as Dan mentioned, the courts are willing to look at the actual terms of the agreement rather than just the label upon which it's headed. Just because a document calls itself a license, for example, if there is exclusive possession of the site that's being demised, then it may be that agreement is in fact lease. So it's just worth bearing that in mind. A person has exclusive possession if it can exercise the rights of the landowner and exclude the landlord and third parties from the land, except to the extent that the landlord may have reserved rights to enter the land to, inspect the property or undertake some repairs. If a landlord does have those reserved rights, then that's a strong indication that there is exclusive possession of the land. And the reason for that is that the courts presume that the whole of the landlord's right to enter or use the land is expressed in that reservation, which implies, therefore, that the tenant or the occupier has possession and control of the land, so they're deemed to have exclusive possession. So it's worth looking at the lease to see whether there's any reserved rights, whether the landlord is limited in terms of how they can enter the land. So in terms of the main distinction from a lease to a license, well, sort of fundamental point really, but a lease is really just permission for the occupier, the licensee, to do something on the licensor's property. It's a personal right only. It's generally only enforceable against the licensor. And because it doesn't attract the protection of the 1954 Act, the occupational status is a lot less certain for an occupier than a lease. Because if you've got a license, then that license can be terminated either according to the terms of that document, or if there's nothing in writing, which you see remarkably frequently, or there aren't any termination provisions in that license document, then you have to give sort of some careful consideration as to what the notice period to terminate that license may be. But in most cases, it's likely to be a shorter notice period than if the agreement were a lease, especially a lease that's protected by the 1954 Act. So a tenancy at will is the third point that I'm just gonna touch on really. They're quite indistinguishable in a lot of ways from a license. It doesn't attract the protection of the 1954 Act, and it exists where there's a tenancy on terms that either party may determine the tenancy at any time. So a tenancy at will, if it is a tenancy at will, can be terminated without notice or upon the terms of the tenancy at will document. So the tenancy at will could be an express agreement. You could have a tenancy at will document, or it could be implied, depending on the context and the circumstances. And they're often used where parties are in negotiation for a formal lease to be granted for a fixed term, and they want a short-term occupational arrangement pending completion of that lease. But as I say, it doesn't have to be a sort of a formal agreement that's been entered into it. A tenancy at will situation can be implied. So there are two sort of scenarios really that I just wanted to touch on as to when we're seeing this kind of debate and analysis come up in practice, when it's particularly important to work out what the status of occupation is for an occupier. The first one is sort of really linking onto the points I made at the end of the last slide, where a tenant starts to occupy a site pending completion of a formal lease. In this situation, whether they've agreed a tenancy at will document or not, it's likely that they will be a tenant at will for the period at least when negotiations are ongoing. Because a tenancy at will can be terminated at any time, and it doesn't have any 54 Act protection, it is a somewhat precarious position for a tenant to be in until they get to the point where a formal lease is agreed. I had a particular case not too recently where I was advising a tenant who had entered into occupation with their landlord without it wasn't documented, but they were negotiating the terms of a new lease. They spent an awful lot of money on the site in anticipation of a new lease being formalised. And then the landlord turned around and said, sorry, I know we've been negotiating, but I don't want to grant you a new lease anymore. So we had to do some analysis to work out whether or not it was a tenancy at will situation, or whether we could argue that potentially a periodic tenancy had been created, in which case the landowner wouldn't be able to give notice to quit, and they'd have to comply with the provisions of the 54 Act. So it's a bit of a precarious situation for a tenant. To do that, I'd probably recommend trying to get an agreement for lease in place before a tenant actually occupies the site, or to get something documented that gives some sort of security to the tenant before a formal lease is completed. The second scenario, again, one I've seen on more than one occasion in the last year, is where a commercial tenant has a lease that's been contracted out of the 1954 Act, but the expiry of that lease is coming up in sort of a few months' time, or has already passed, and the tenant remains in occupation post-expiry. Now, the danger really for a landlord in that situation, where a tenant remains in occupation post-expiry, is that the more time that passes between the expiry of the lease and the landlord taking some action, the more likely it is that the former tenant's continued occupation could either be deemed to be a tenancy at will or even a periodic tenancy. And that's even if the original lease was contracted out of the 54 Act. So it is certainly possible that if the landlord doesn't do anything and the tenant remains in occupation, pays rents and continues to occupy for a period of time, that they could be deemed to occupy the property under a periodic tenancy, and that periodic tenancy would attract the protection of the Landlord and Tenants Act 1954. So in that case, a landlord has gone from having a contracted out lease to suddenly being lumbered with a periodic tenancy and not being able to terminate that as quickly as they might otherwise have been, and they might have to rely on various statutory grounds in the Landlord and Tenants Act. So, I mean, in terms of sort of best practice, really, to try and avoid that situation, I think it's fairly obvious in that, you know, prepare early, contact the tenant sort of 6, 8, 9 months, however long before the lease is due to expire, just to ascertain their future plans for the premises. If they indicate that they want to remain and they would like a new lease, then you can commence negotiations. However, if it gets close to the expiry of the contracted out lease and it's not known really whether the tenant's staying or going, then best practice really is to do one of two things. You can either, or do both at the same time, send an open letter to the tenant demanding possession upon expiry of the lease, and if the landlord's minded to agree to enter into a new lease, then it could send a separate without prejudice letter to the tenant saying we won't issue possession proceedings for a short period of time, just to allow negotiations to take place. However, if it doesn't appear that the tenant wants a new lease, but they're also you know, not vacating the site, then the landlord really needs to be taking prompt action to take back possession, and should probably consider putting a rent stop in place to avoid the inadvertent acceptance of rent and an argument being raised later by the tenant that they had a periodic tenancy. So that's really just a couple of sort of practical scenarios just to illustrate how this has come up in practice and why it has, and some of the issues that have come up as a result of it. I'm just going to move now on to talking about break notices, because that's another hot topic. I'm appear to be serving I served 2 break notices yesterday. I've got another break notice to serve later today. I've served sort of triple digits since the start of the year, probably, on the tenant side. So it's something I'm seeing an awful lot of. You know, I think it's symptomatic of the world we live in, that we've got a lot shorter leases and tenants exercising breaks more frequently, it seems. So I'm just going to touch on some fundamentals and try and include a few sort of tips in there as to, you know, how to practically deal with them. I'm sure many on the call know what a break option is and what a break notice is, but just for those that aren't necessarily in the know, it's an option which, if correctly exercised, enables the landlord or the tenant to terminate a lease early. It can be exercised only by the person who holds the legal estate in the lease or the reversion. And by that I mean it's the party that is registered in England at the land registry as the registered proprietor of that interest. The beneficial ownership of the land isn't sufficient to validly exercise a break option. So that leads to something called the registration gap, sometimes in certain circumstances, which is the gap between a purchase completing, you know, you sign the transfer document and away you go, and the registration at the land registry completing, because once a purchase happens, the solicitors will make an application to change the register in England at the land registry. And until the land registry sends that completed registration document back, that party is not the owner of the legal estate in the lease or the reversion. So until that point, you won't be able to exercise a break notice. So if there is a cause for needing to do that before the land registry have done what they need to do, then it may be the case that you need to involve the previous owner or the previous tenant of the land to enable you to validly exercise that break option. Clearly, it's important once you've ascertained that there's a break right and that it's something that you want to do. You need to work out what the notice period is. I'll say this a couple of times probably. You need to read the lease wording really carefully with break notices for a few different reasons. The first reason is to work out how much notice needs to be given. It's usually relatively obvious. It will, the notice period may be linked to the term commencement date of the lease, or maybe the date of the lease itself if that's different, or maybe an anniversary of either of those. Sometimes the break clause may specify an actual date, and you just need to sort of work back in time from that break date to work out exactly how much notice needs to be given. And usually a lease will say something like, by giving at least 3 months or 6 months notice in writing. But just be careful just to read the words precisely. I've had a couple of break notices recently where the clause says that you need to give 6 months notice, and that is, in that situation, I would be giving precisely 6 months notice. I wouldn't be, if it doesn't have not less than or at least in front of it, then arguably you have to give exactly 6 months notice. So it's worth just making sure you read the wording carefully. In terms of serving the notice, most break clauses will say just that it needs to be given in writing, which is fine. That can be done by yourself or your solicitor in the form of a letter. But occasionally, and I've seen this in a couple of recent cases that I've been dealing with, where a lease actually has in a schedule a prescribed form of notice that needs to be used, that the parties have agreed that that's what it's going to look like, the break notice. If that is the case, then use that form of notice. Don't decide that you're going to just do it a different way. There is a well-known case called Manai that deals with the service of notices and may potentially sort of remedy a defective notice if the reasonable recipient understood what they would be receiving. But I wouldn't like to rely on that. It's a fallback that could be used, but I would prefer not to. If there's a particular form of notice, or if the lease prescribes a particular method of notice, i.e. by post, by hand, however it says it, then I would just follow it to the letter, because you're opening yourselves up to an argument from somebody from the other party that maybe the break hasn't been validly exercised. So read the lease carefully, read the notice provisions carefully. Most break options will come with conditions. They will say that the break is only effective if on the break date, for example, the rent is paid up to date, vacant possession is given, or any continuing under leases have been ended. All conditions should be strictly complied with. If they're not, then there's a chance that the break will not be effective. I've just put a point there about engaging a surveyor. I wouldn't ordinarily necessarily recognise or advise this, but I have seen leases where it will include a condition that says something along the lines of that the tenant must have performed and observed its lease covenants. Something quite wide that suggests that if they have not performed and observed all of the covenants in the lease, that the break might not be effective. So you're looking at that potentially brings in things like dilapidations and other considerations. So it's worth, if there is that clause in there, just flagging that and potentially maybe engaging a surveyor to have a look at what potential breaches there might be at this date, and can they be dealt with between now and the break date, whenever that is. I'm just touching again on the Landlord and Tenant Act, obviously, which is just relevant for the English properties. It's only really relevant in the context of landlords' break notices. It doesn't really have any bearing on a tenant deciding to exercise a break. But if the lease is within the 54 Act, i.e. it hasn't been contracted out and it meets the other qualifying criteria, then the landlord can only fully terminate the lease by also serving notice under Section 25 of the Landlord and Tenant Act. What a break notice does is it will end the contractual lease, but because of the statutory provisions of the 54 Act and the fact that it has protection, a landlord would also need to terminate the statutory tenancy. So in that situation, it may be that you need to serve a break notice and a Section 25 notice to make sure that you fully terminate the lease. And that sort of raises some complications because the Landlord and Tenant Act has particular amounts of notice that need to be given to use a Section 25 notice. You have to give between 6 and 12 months notice. So you need to tally that up with the amount of notice for the break option as well, and make sure that those are aligned so that you're terminating both the contractual and the statutory tenancy. It's just a flag if it's within that tenancy and you're the landlords looking to exercise a break. The effect of a break notice is fairly obvious, and I've sort of touched on it. It will bring the lease to an end on that date. A break notice that is served can't be withdrawn unilaterally. The parties to the lease could mutually agree that the break notice is to be withdrawn, but this is deemed as a matter of law to constitute the creation of a new lease with effect from the expiry of the break notice. So that may not be what is required. So once a break notice is served, that's really it in terms of that. It can't be withdrawn unilaterally. It's also worth just considering whether there are any subleases in play. The sublease will end as a matter of contract after the head lease is, a break notice has been served in respect of the head lease, but it may be that the subtenant has 1954 Act protection, the landlord and tenant protection, and they may have the right to apply for a renewal lease from the head landlord. So if there are subleases, it's worth just giving some consideration to that. Lastly, really on the effect of a break notice, just in terms of the rent, you'll usually be, a tenant will usually be paying rent in advance for, a quarter, for example, and it may be that the break date falls sort of within a rental period. So you paid rent in advance for 3 months, and then the break date's only a month into that period. A lot of leases these days provide that where that is the situation, the landlord will repay some to the tenant at a certain point after the break date. But if there isn't a clause to that effect, or if there isn't that in the lease, then there isn't an automatic entitlement to a refund on the part of the tenant. And there was a Supreme Court case, called Marks and Spencers and BNP Paribas that came down on that point. So if there isn't a repayment clause, make sure you pay the rent in full, even if you think that it would be fair that you apportioned it. I would pay it in full rather than apportioning it, just to make sure that you're not falling foul of a condition in the break option itself. Lastly, just a few tips just to finish. I focused on tenants, although some of them are applicable to landlords. Clearly, for me, a break option is particularly relevant for tenants. They don't want to be left on the hook for rent for the duration of the lease if they mess it up. So the first tip really is to sort of prepare early, diarise the break dates and the notices that need to be given. Instruct a solicitor in plenty of time if you're going to use one to exercise the break. Once it's served, keep any evidence of the method of posting or the delivery of the notice. That may be useful if there's any sort of argument later on as to whether the break was validly served or how it was served. If there's a wide-ranging compliance with covenant condition attached to the break, then maybe a compliance audit with the surveyor would be a good idea before serving the break, just to identify any breaches and work out how you're going to deal with them. And the last point is really just to make sure all sums that are due under the lease are paid in full. Even if you think those sums are in dispute, you could make a payment of disputed sums on a without prejudice basis and dispute them later. I would recommend doing that rather than holding sums back and leaving an argument open, perhaps that the break hasn't been sufficiently complied with. It's probably better to pay in full and have the argument later, I would suggest. So that brings me to an end, and thanking the stars that I didn't get interrupted again. I'm just going to pass back over to Dan now, who's going to touch on the rest of the Scottish stuff.
Thanks, Lawrence. So yeah, I'll just get my slides back on screen. So yeah, I spoke earlier about the lease against license issue in Scotland. So I'll not come back to that, but just kind of get straight into break notices. I mean, the law really in relation to break notices is broadly the same north and south of the border. What I'm really going to do here is just kind of look at a few Scottish cases and one English case that kind of illustrate some of the considerations and some of the pitfalls that kind of rise. And in particular, I'm going to look at a very recent Sheriff Court case in Scotland where the sender of a break notice tried to argue for a less strict approach. We'll see how that party got on in a few moments. But you know, Lawrence commented earlier on the amount of break notices that he's being instructed to serve, and I think, you know, when in difficult economic circumstances, it's you know, break notices kind of perhaps assume a greater importance, both in relation to, you know, the importance of getting it right and ensuring that your notice is valid, but also I think perhaps you know, there's a greater scrutiny on the other side, you know, the party receiving the break notice who perhaps doesn't want to receive the break notice, and I might be you know, having a keen eye on whether it has been validly served. So you know, it's important to bear a lot of these considerations in mind. And I say that the principles are broadly the same north and south of the border. You know, if there are conditions that are specified in the break clause, they have to be complied with on time. The notice has to be served on time in accordance with what the break clause provides, and the notice needs to comply with the formal requirements of the lease. Now, Lawrence mentioned an English case earlier, Manai Investment Company against Eagle Star Life Assurance. It was a House of Lords case from 1997, and in that case, the court kind of drew a distinction between. I mean, it was a case about an error in a break notice, and the court drew a distinction between errors which fail to meet the requirements of the contract and errors in the content of the notice. And broadly speaking, what the court determined was that if the notice met the requirements of the contract, then an error in the contents of the notice might not invalidate it, and that depended on the application of what has come to be referred to as the reasonable recipient test. And basically, in this case, the break notice had within it the wrong date of termination, and what the court did was, it ultimately concluded that the notice did actually meet the sort of requirements of the break clause, and that really this was an error in the contents of the notice. So the court determined the validity of the notice by asking, well, how would a reasonable recipient have understood it, bearing in mind the context of the notice? And the ultimate conclusion was that the reasonable recipient with knowledge of the lease terms would have been left in no doubt that the tenant wished to terminate the lease on the correct date. So ultimately, the notice was held to be valid. So as I said, if there is an error in the contents of the notice, you might be okay. But it's obviously best to try and avoid that, because, ideally, and as Lawrence has said already, you don't really want to be having to try and rely on the reasonable recipient test to save you if your notice might be invalid. But as far as this distinction is concerned, as I say, it's important to keep that in mind. That this distinction between, as I say, errors which fail to meet the requirements of the contract and errors in the content of the notices. And in relation to errors that fail to meet the requirements of the contract, there's a notable quote in the case from one of the judges. We said, if the clause had said the notice had to be on blue paper, it would have been no good serving a notice on pink paper, however clear it might have been that the tenant wanted to terminate the lease. And I think that just illustrates the point. You need to comply with what the contract says. And that approach has been, has very much been followed in Scotland. There's a case from 2010, Bat Cables against Spencer Business Parks, following on from an earlier appeal court case in Scotland, Benclew Estates, where the judge in that case kind of again sort of drawing this distinction said that before the court construes the meaning of the notice by use of the device of the reasonable person in the position of the contractually specified recipient, so essentially the reasonable recipient test, it must first carry out the test of which Lord Clyde spoke in Manning Investments, which is does it meet the requirements of the contract? If the notice fails to meet that test because one or more of the contractual requirements for the exercise of the power have not been fulfilled, the court does not go on to apply the reasonable recipient test to construe the notice. That's because it's invalid. So you essentially have this sort of two-stage approach to determining the validity of the notice. That was illustrated by a later case in Scotland, a case from 2015, West Dunbartonshire Council against William Thompson and Son Dumbarton Limited, which is another one that reached the appeal court, the inner house of the Court of Session. And in this case, the rent review notice was incorrectly addressed to William Thompson and Sons Limited, rather than William Thompson and Son Dumbarton Limited. Nevertheless, the notice was received by the tenants and it was opened by one of their directors. But despite that, the court held that the notice failed to meet the requirements of the lease, and so on that basis, it was invalid. It wasn't given to the tenants as defined in the lease, and it wasn't duly addressed to the tenants as provided for in the notice provisions of the lease. So even though it was received by the tenants, the reasonable recipient test did not save the landlord there. It just simply failed to meet the requirements of the lease. Now, a couple of years later, there was a case, again, another one which reached the inner house of the Court of Session, which possibly muddied the water a little bit. Now, this one didn't involve a break notice, but there are a few comments that the court made that I just want to kind of pick up on. Again, the court picked up on this kind of distinction. The quote's up on the screen here that it's saying two distinct issues may arise. First, whether the terms of the notice itself are sufficient to convey the necessary meaning to the recipient. Secondly, whether the method of sending the notice is in accordance with the provisions of the contract. But then, you can see at the end of that quote that the last sentence that the court's saying, in general, it can be said that recent cases disclose reluctance to adopt an over-formal attitude, provided that the notice itself is sufficiently clear and is actually received by a responsible person. So is this signalling perhaps a sort of relaxation in the court's approach to notices? Again, there's another quote there I've got up on the screen. The court's saying that the crucial question is normally whether strict compliance is required with one or more requirements of the clause. And the court then going on to say, well, in determining that, ordinary principles of contractual interpretation will apply. You need to have regard to the terms of the relevant clause. The clause has to be construed in the context of the document where it's found, and in the general contractual context. The requirement has to be given a purposive construction, the court said, and where appropriate, commercial common sense needs to be applied. And the court went on to say that in this area, the need for a purposive construction, i.e. a purposive interpretation, appears to be particularly important. And what the court said, the parties need, that there needed to be a focus on the core obligation or requirement, concentrating on what really matters rather than being preoccupied with a morass of detail. And said that in relation to the validity of a contractual notice, two distinct purposes are potentially relevant: the purpose of the notice itself and the purpose of any particular requirement that's not been complied with. And there's a comment here: in general, it may be said that the more drastic the consequences of a notice, the greater need for strict compliance with what's prescribed in the contract. Thus, a notice may bring about a fundamental alteration in the parties' legal relationship, as with a break clause in a lease, which brings the contract to an end, or an option to purchase. So what you can see there is an indication that, well, in certain circumstances, there might be a relaxation of this, this strict requirement, but not necessarily with a break notice, because it has a pretty, it has quite drastic consequences. It kind of changes the parties' fundamental relationship. But there's some later comments in the judgment that, again, perhaps muddy the water and perhaps signal that even in the case of a break clause, there might be a relaxation of this strict requirement. And here what you have the court saying is, provided that the notice arrives in the hands of the person it needs to arrive in the hands of, other requirements may not be important. The fundamental question is perhaps, if a particular formal requirement is not complied with, is the would-be recipient prejudiced in a practical sense? If there is in fact no prejudice, the court should, in our opinion, be slow to hold that failure to comply with a formal requirement is fatal. That is so even in cases where the purpose of the notice is drastic, as with a notice invoking a break clause or an option to purchase. If there is no prejudice, insisting on strict compliance for its own sake serves no useful purpose. So where does that leave us? I mean, I think, that, I think unhelpfully kind of left, landlords and tenants in a situation where, there's a little bit of uncertainty about, if there is an error in a notice, do the requirements of the contract need to be strictly complied with or not? But there was a recent case, very recent case. This actually, the judgment came out just a couple of weeks ago. A recent sheriff court decision where the sheriff did have to grapple with this issue, and I think perhaps brings a little bit of certainty back into the issue. So, very briefly, the kind of facts in this case, Hingston against Craig Ellen Assets Limited, were that there was a lease between a partnership, Graham Murray and Co, and Craig Ellen Assets Limited, premises up in Aberdeen. The partnership that was the tenant, Graham Murray and Co, was dissolved, and its assets were purchased by a former partner of the partnership, and those assets were used to set up a new company called Hingston's Law Limited, HLL. HLL then occupied the premises and implemented the obligations of the tenant under the lease. There was then a break notice that was served on behalf of HLL, and the question was whether that notice was valid. Now, the particular clause in the lease, kind of fairly standard break clause, it provided that the tenant shall be entitled to terminate the lease as at a particular date, subject to providing the landlord with not less than 6 months prior written notice. But it was clear that the notice had been served on behalf of HLL. Looking at the sort of the terms of the notice, and in particular the fact that it was signed by a solicitor. At the bottom there was the signature, and then there was the name of the firm of solicitors, and then it was expressed as being as they were agents for and on behalf of Hingston's Law Limited, and Hingston's Law Limited was referred to in the body of the notice as their client. So the notice was served on behalf of HLL. Now, the sender of the notice kind of tried to argue, actually, in the case it was the former partners of the partnership, and they raised the action essentially for an order declaring that the lease had been validly terminated by that notice, and they argued by reference to some of the comments in Ho International that I referred to earlier that signalled perhaps a sort of relaxation of that strict approach. that they argued that the notice was valid. One of the sort of arguments that they made was that what comprised the tenant was fluid and subject to change from time to time, and that there was a complex factual background, and that when you look at all of the facts, that actually ultimately this did amount to a valid notice. But the landlord, Craig Ellen Assets Limited, very much relying on the sort of earlier case law that I referred to, and the comments in Ho International about the drastic consequences of a break notice, argued that it just simply was not valid because it didn't meet the requirements of the lease. And the sheriff agreed with that. He again, considered Ho International and the sort of earlier case law that I referred to, and determined that the nature of the notice, being a break notice, was such that it required a greater need for strict compliance. The particular clause of the lease required the break notice to be given by the tenant, and in this case, the notice wasn't given by the tenant, and on that basis, it was invalid. So the lease continued essentially as between the individual former partners of the partnership, who were in terms of the lease jointly and severally liable for the obligations of the partnership and the landlord. There were arguments in the case as well about the reasonable recipient test. Had the sheriff, there were essentially issues according to the landlord with the notice, that it apparently it made no mention or explanation of the break clause or the option itself, and apparently contained the wrong date. But the tenants were arguing that that the reasonable recipient test meant that actually, notwithstanding any of that, that it was valid. What the sheriff decided there was that had the notice been valid, had it complied with the strict requirements of the release, the sheriff would have allowed a proof. The case was determined on the basis of legal arguments alone, but had the notice been valid, been determined to be valid at that legal debate, the sheriff would have allowed a further hearing, a hearing of evidence, to hear evidence about the factual circumstances to determine whether the reasonable recipient test saved the notice. But it wasn't necessary to do that because the sheriff had already determined that the notice was simply not valid because it didn't meet the strict requirements of the lease. Having said that, there was also another argument here, again by reference to the particular factual circumstances here, and it was argued that because of essentially certain representations that were made by the landlord, that the landlord was barred from arguing that the notice was invalid, and that was on the basis of the Scottish law principle of personal bar, broadly the equivalent of estoppel in England, which you may have heard of if you're south of the border. Now the sheriff on that argument did allow a proof, did say, well, there's maybe enough that there's enough here to mean that we should hear evidence about this to determine whether the landlord is personally barred. But I think what this illustrates is that really, you don't want to be getting into a situation where, for either party, where to determine whether your notice is valid or not, you're having to have a proof in court at which evidence is led. So I think it really comes back to some of the tips that Lawrence mentioned earlier on, and there's one in particular I think that I would flag in a sort of shameless plug for the services of solicitors, which is, if you're serving a break notice, I think I would always recommend instructing a solicitor to do that, because otherwise, I think there are just too many pitfalls, and you're running the risk that the party receiving it might argue that it's invalid. So I would always recommend getting a solicitor involved. There is, let's see, the slides will be coming out to everyone who's attending the seminar, but I've got in there the slide that quote from the case, where the judge, the sheriff is essentially explaining why this just simply wasn't a valid notice. But in that, he picks up on the need for certainty, essentially. He's saying that if notices from third parties who are not party to the contract were to be considered relevant when considering break notices, then this leads to a considerable degree of ambiguity and uncertainty in the commercial world. So, where that leaves us, I think, is here's an indication that despite the possible muddying of the water arising from Ho International, the signals that were perhaps in that case that there might not be a need to always strictly comply with the requirements of the contract. You can see here, a sheriff saying, well, actually, that's going to lead to ambiguity and uncertainty, and in fact, we do need, strict compliance. So, I think just very, very important to bear that in mind. Okay, that was all I had. I think we've got a few questions, so I'll hand back to Colin to take us through those.
Thanks, Dan, and thank you, Lawrence, and thank you in particular, Lawrence, for your persistence in getting over the hurdles posed by your internet connection. But we got there in the end, and I'm grateful for the patience of the audience as well. As Dan said, we have several questions. One, Dan, I think you're going to pick up the question that's come through in relation to the M7 case. It may well be that some of the other, apart from the person who's asked the question, there may be people that are not familiar with the background. So it might be worth just briefly reminding the audience of the background to that case and addressing the question of whether the decision in that judgment reflects the law of Scotland now.
Yeah, so the case is, it's M7 Real Estate Investment Partners against Amazon UK Services, and the landlords in that case, the M7, they'd served a notice to quit on the tenant to terminate the lease, and it was they'd given just under 6 months notice, but I mean that met the requirements of a common law notice to quit of giving at least 40 days notice to quit. But the tenant argued that it wasn't valid because of a provision in the old legislation, the Sheriff Court Scotland Act 1907, and it's section 34 in particular, which essentially contains provisions about needing to give not less than, I'm sorry, just get the provision up in front of me. Yes, lands exceeding 2 acres in extent, and the need to give more than a year's notice in those circumstances. And essentially, I think what the tenant was arguing was that the landlord needed to give, because the premises here were of that extent, that they needed to give at least a year's notice.
I'm just sorry to butt in, Dan, again, to give a bit of context for those that know the area. The case relates to the Amazon depot, if that's the right way of describing it, outside Dunfermline. So if you've ever driven past it on the M90, you'll know that it's significantly in excess of 2 acres in size. Yes.
So, and it, it's a pretty arcane legislation, and its language is not ideal in many respects, but essentially what the conclusion that the court came to was that that provision didn't alter the common law. in terms of if the premises were, you know, of that sort of extent, if you wanted to use what was essentially a summary procedure for removal in section 34 of the 1907 Act, then yes, you did need to give at least a year's notice. But that didn't mean that you couldn't serve an ordinary common law notice to quit instead, and use an ordinary, you know, essentially a common law remedy, an ordinary action for removing. So essentially, the court determined that you know, the lease, you know, had been terminated. The common law notice to quit prevented tacit relocation from operating. I mentioned tacit relocation earlier on. You know, that principle in Scots law that if a notice isn't given, that the lease continues from year to year until a valid notice is given. The common law notice to quit prevented that from operating, and it meant that the landlord could rely on common law remedies to essentially recover the premises, but couldn't use the sort of summary procedure under the 1907 Act. So essentially, you know, you don't always have to give at least a year's notice. You only have to do that if you want to use that procedure.
Thanks, Dan. And there has been at least one other case in the last 5 years or so that's confirmed that position, that it is very much intended that if you give over a year's notice, that's with a view to using that summary procedure. This whole area of the law might be subject to reform on the basis of legislation that's currently going through the Scottish Parliament. So we'll see, I think, a bit of tidying up would leave the law much clearer than it currently is, and hopefully remove some headaches for practitioners and landowners and tenants, and so it goes on. But we'll see what happens on that front. We had another question, a very good question, which is exclusive possession something you determine from the terms of the agreement or the facts on the ground? And I think that gets to the heart of the position with regard to leases and licenses in Scotland. Lawrence, I'll allow you to pick up and tell me whether you think there's any distinction with the position in England in a couple of minutes. But you can call it what you like, but if the facts on the ground indicate that the position with regard to possession, whether it's exclusive or not, is one that supports it either being a lease or a license, then I'm not sure that the badge that you give to your written agreement is going to get you very far. So, I mean, I suppose to try and illustrate that, if you have, or you have no, you have a very informal arrangement, and you have a situation where it's claimed by the landlord that the arrangement that is in place is non-exclusive and therefore in the nature of a license, if, as a matter of fact, an examination of the position on the ground indicates that there is exclusive possession, well, if all the other elements of a lease are in place, the occupier may well have a basis for asserting that there is a tenancy in place. So yes, I think it's always likely to be more important to look at what the factual position is, as opposed to the way in which people try to describe things in a written document, since occasionally that might either willfully or otherwise not give a true indication of what the factual position is. Lawrence, is there anything, I'm obviously speaking from the perspective of a Scottish lawyer, is there anything more to add from the English perspective?
Thanks, Colin. Not really. I think the position's broadly the same. I mean, you'd be looking at everything, wouldn't you? You'd be looking at all of the circumstances. You'd be looking at whatever document is in place, if there is a document, and seeing what the terms of that are. And then you would look at the position on the ground. Is it the same? If it isn't, then why is it different? And what's the possible effect of that? And yeah, there's a few cases. There's a Court of Appeal case that says that the courts are more than willing to go behind what a document is called to ascertain what the true situation is. So if you had a something that's called a license, but there's a big gate around the site, and the landlord can't come and go as they please, and you've got full control, then arguably there is exclusive possession, and as you say, if the other elements that are required for a lease are also in place, then quite possibly it's definitely an argument to be had there. So
the comment I would add here is that, I mean, in terms of determining whether there is exclusive possession or not, I mean, I think the terms of the agreement are important, because I mean, yes, you have that, what the parties call it is not determinative of the position, but the position on the ground, as far as possession is concerned, ought to reflect what rights are given to the parties, what rights and obligations the parties have in terms of the agreement. So I think it is important to look at the agreement and say, well, in terms of what has been agreed here, has exclusive possession been given? Because thinking there may be circumstances where the agreement doesn't. If you interpret the agreement, it doesn't actually give exclusive possession, but the position as on the ground may be that, in fact, the occupier does. But the landlord might have a right also to possess part of the premises. It just that might not be apparent just from looking at the position on the ground. So as you said, Lawrence, you have to look at everything, I think. And if the position on the ground is different, why is it different? In terms of determining whether there is exclusive possession or not. Things like that, it's all kind of fenced off. That might, again, you would expect, as I say, you would expect the position on the ground to follow what the agreement provides.
And I guess the difficult circumstances are the ones where that isn't the position, and that's when you're trying to reconcile the two. And you're quite right, Dan, to say that you ought to look very carefully about what the agreement provides. But if there's a tension between what the agreement says on the one hand and the position on the ground, that's where the facts, in whatever shape or form, and obviously the written document will be part of that factual matrix, will be fundamental to determining what the correct legal analysis is. And the same participant has asked a follow-up question, which is, when drafting a license, are you safer to not include any reservations to the landlord? Is it ironic that the more reservations you include in an agreement, the more likely you are to have a lease, when a license is the agreement where the landlord retains most rights to the land? You're nodding away, Dan. So do you want to have a first crack at that?
Well, I can see what the question is getting at. Yeah, because I suppose if you're expressly providing for reservations, does that sort of indicate that, in fact, the need to do that means that there is exclusive possession, and that the landlord is needing to rely on those express reservations? But it's difficult to generalize with this. I think it's always going to depend on what rights are given to the tenant, and an interpretation of what rights are given to the landlord, and kind of coming to a view on the basis of that. Well, okay, but is this exclusive possession or is it not? But yeah, I can see that in certain circumstances, yes, the more reservations you have, the more express reservations you have, that might, the fact that parties have considered those to be necessary might perhaps indicate exclusive possession and therefore a lease. But yeah, it's difficult to generalize. It's always just going to depend on the precise terms.
Lawrence, was there anything you wanted to add to Dan's answer?
I don't think so, really. No, I mean, you see reserved rights very, very frequently, don't you, with leases, and then they don't tend to appear in licenses. I think it's just a case of just reading carefully what limitations there are on a landlord's sort of coming and going from the site, and trying to analyse whether or not that means that the tenant can sort of go about their business uninterrupted to some extent. And oftentimes there'll be, the landlord will have to give some sort of notice to the tenants, it might be 48 hours or 24 hours unless there's an emergency. So it's really just a case of carefully reading what's been agreed and analysing it from that perspective.
Great. Okay. I think that's us made our way through the questions. So thank you very much to the participants for sending them in. We're a few minutes ahead of time as well, so we will draw matters to a close there. Just before I do that, a reminder that we will send out the slides that Dan and Lawrence have prepared, and we'll send out the recording of this morning's seminar. And it only remains for me to say thank you to Dan and to Lawrence for their presentations this morning. Thank you to you all for joining in, and looking forward to seeing you in a virtual fashion on our next seminar. Thanks very much.
Thanks, Rudy.
Thank you.